Next, we have the privilege to have as speaker a living legend. Professor Jules Stuyck from University of Leuven and from Radboud University is emeritus professor, actually, and also a well-known practitioner of EU law, being also now a partner with Liedekerke, Bolters. Am I even remotely, even remotely close to the correct pronunciation? Professor Stuyck actually, would continue, if I am allowed to say so, the presentation that Professor Toader has just made, because Professor Stuyck actually will enter into technical details pertaining to preliminary rulings. We have learned the general frame of awarding preliminary rulings, and we have entered into some very, very specific details by means of examples that Professor Toader has just provided. But we are to take a further step, as Professor Stuyck will speak about the role of preliminary rulings in the uniform applicability of competition law. Thank you, Professor.
Thank you very much, Adriana, for your kind words, also for the invitation. It's my first visit to Bucharest, and I must say that the very well-known hospitality of the Romanian people has been proven during my stay and will continue to be proven, I hope. Now, I also would like to thank Judge Toader, because she has actually dealt with a certain number of questions I would have to explain to you, basic questions, which she explained very clearly on direct effect, on the respective role of the Court of Justice and the national courts, and some other issues. I would also like to apologize that I will have to, and just 1 second, it's still early in the morning for me, and we had a nice dinner yesterday evening, so this being cleared, I would like to apologize for having to bother you with technical details, as it was said. I will try to limit that. Okay, so I would like to address some questions here. What is the scope of preliminary questions? You have already heard that only courts can refer questions. And then, of course, I would like to focus on the interaction between EU competition law and national competition law, because that is so special in the area of competition law. Knowing that Articles 101 and 102 of the TFUE have direct effect, and having heard yesterday that according to Regulation 1/2003, there has to be some coherence between the application of national competition law and EU competition law. This means that we have a certain number of preliminary references that actually have been asked by national courts when they were applying national competition law. So this is something special, I think, for competition law. The respective role of the national court and the Court of Justice, of course, and I will also give you some examples, practical examples in competition cases. Article 267 of the TFEU, you will see that it's questions either on the interpretation of the treaties, so like Article 101, 102, but also on the validity and interpretation of acts of the institutions, bodies, offices, or agencies of the Union. We have a lot of bodies, agencies these days, and there is a lot of litigation before the General Court, for example, against these bodies. Now, this is a very general statement because it's secondary law and it's not even binding acts. It can be everything. And indeed, there is some case law on, for example, a council resolution, an interpretation of a council resolution, already an old case. There are not many examples, I think, of European soft law on which you would have preliminary questions, but in itself it is possible. The question of the validity is important because national courts cannot decide on their own motion. They cannot decide without having asked the Court of Justice whether a secondary act is valid or not. And so it happens that, and I give you the example of Vodafone, it's about the roaming regulation, which is a proxy for competition law in a sense, because the tariffs for roaming have been fixed by a regulation of the European Union, and an English court has referred to a matter on the validity of the roaming regulation, and the court has said that it was not invalid. Now, in competition law, I'm not aware of a lot of questions on the validity, although it could happen. There is, as you have already heard, an obligation on courts in last resort, typically a Supreme Court or Court of Cassation or something like that, to refer questions on interpretation, while for lower courts this is a possibility. You will see that in some countries, like my country, Belgium, lower courts, especially Court of Appeals and sometimes courts of first instance, are quite active in referring questions to the European Court of Justice. This obligation for the Supreme Courts, the courts in last resort, does not apply when you have what is called an acte clair, meaning that it's clear it's obvious what the interpretation is, or where it has been explained already by the court, which is called acte éclairé. So this is the famous Silphid judgment of many years ago. It is even possible, and this the court has confirmed in Grithan, that where that court, Supreme Court, has to follow the opinion of a constitutional court, it still is under a duty to refer a matter to Luxembourg. This is quite interesting, but it is not competition law, so I will not enter into this debate. So I will not go too much on this either. Just one point is that, for example, guidelines on fines of the European Commission have not made the object of preliminary rulings, but you will find in the case law of the General Court and the Court of Justice some considerations. Actually, in direct actions, you can have elements of interpretation as well. The point of courts only, and yesterday Adriana was discussing arbitration. It's generally accepted that arbitrators cannot refer matters to the Court of Justice, but if you look at the recent Merck Canada case, you have to be prudent, because if an arbitral tribunal is established by law and the decisions are binding on the parties and the jurisdiction does not depend on their agreement, so it's a kind of a state compulsory arbitration, then although it's called an arbitrational tribunal, that can refer matters to the Court of Justice. Now, what is more interesting for us is the question whether competition authorities can refer matters to the Court of Justice. As such, they cannot, but of course in many member states you would have a review court after the decision has been taken by a national competition authority. Then you will have a review before a court of law, and that court of law, of course, Court of Appeal and Supreme Court and so on, refer matters to the Court of Justice. I say normally not competition authorities, because you will have to look especially what is the task, the composition and so on of the authority before to decide whether it can refer matters or not. But generally that will not be the case. So now I come to the heart of our discussion today, because this is the question: to what extent the Court of Justice can help in the interpretation of national competition law. It all started with a case which was not about competition, Zodzi, where the court said that where union law is made applicable by national provisions, and the national court takes the view that the content of a provision of union law is applicable by virtue of these national provisions to the pure internal situation underlying the dispute, then national court is entitled to make a preliminary reference. Now, let me explain that to you in competition law. If you take our Belgian Competition Act, you will find a provision to the effect that where you have a block exemption regulation, and all of you know now what a block exemption regulation is, it is an exemption from Article 101 of the treaty. It means that the prohibition of restrictive agreements will not apply because you have a declaration of inapplicability. Now, this is union law, but if you have simultaneous application or the sole application of national law, as is the case in my country, the provision of the law says that the block exemption also works in the national legal order, meaning you are exempted under national law, which is not an obligation under EU law to provide for that, but it's it may be a good example, and it is an example of the fact that of what is said in Zotzi. So you refer in national law specifically to union law. There have been some doubts about the possibility to refer questions which were linked to national law in the Kleinwort-Benson case, but this is a quite peculiar case I will not discuss today. But of course, questions will be inadmissible where union law clearly cannot be applied. We have some more recent cases in the area of competition law to explain that to us. One case is the Autorità, so this is the Italian competition authority. It's a grand chamber judgment, so it's an important case, not an extremely important case, which would come before the plenum, but an important case. And I quote from this judgment, it says, where in regulating purely internal situations, domestic legislation provides the same solutions as those adopted in community law, so that's even another criterion. In order to avoid future differences of interpretation, provisions or concepts taken from community law should be interpreted uniformly. So this is the idea of uniform application, which we have also seen in Regulation 1/2003. And that irrespective of the circumstances in which they are to apply. Now, if you look at the different cases like Allianz, which we discussed yesterday, and 80, then you come to the conclusion that if you have national law that provides for the same solution for domestic situations as EU situations, then the national provisions have to be interpreted in accordance with the principles of EU competition law. So this is quite interesting. So it also helps, here the Court of Justice is helping in the uniform application and the coherence between national competition law and EU competition law. We have some further cases, evidence of this in other judgments like Confederación Española de Empresarios de Estaciones de Servicio, and the 80 case already mentioned, and in Allianz Hungaria. If there are some hesitations, then we always have to keep in mind that the Court of Justice has to strike a balance between, of course, guaranteeing the uniform application of union law and helping the national courts in that respect on the one hand, and avoiding a floodgate or to be used for strict internal purposes on the other. So this is always a danger. You always need some filters. You can be generous, but you should not allow all the cases to come to you, because at the end of the day, we can just scrap the national courts and we do with the Court of Justice, and it will resolve all the problems. This is not the idea. Now, there are cases where the Court of Justice will refuse to answer a question, and that is settled case law now. Amongst other things, the Allianz Hungaria is an interesting judgment because we discussed it yesterday on substantive elements of competition law, but it is also interesting in this respect. The court may refuse to rule on a question submitted by a national court only where it is quite obvious that interpretation of European Union law that is sought bears no relation to the actual facts of the main action, which is quite clear. Also where the problem is hypothetical. Well, what is hypothetical? We remember the old cases, Folia Novello, in the past, where a judge was asking it because parties can agree on something and then they put a question and then it goes to Luxembourg, but actually there is no real case. But this is rather exceptional. Or where the court does not have before it the factual or legal material necessary to give a useful answer. And that is, of course, a possibility for the court to turn down the national court to say, well, we don't understand what you're talking about. We cannot give you an answer because you have not explained to us exactly what you want to know. And it also happens, and more I see, because especially not in this matter, but for unfair commercial practices, you will find a lot of recent orders of the court that are not called a judgment. And then there is a provision in the rules of procedure providing that where the answer has already been given, the court can answer and referring to the judgment in an order. But if you look at the content of the orders, you will see that there is a whole reasoning in it. So there are disguised judgments in orders, I would say. But this is not the case so far in competition. Now, if we, this is an interesting case. It also concerns the Belgian Competition Act. The problem was that the competition authority, the Council for Competition, did not have to appear before the Court of Appeal. You had a case by a company brought against a decision of the competition authority before the Court of Appeal, and the competition authority would not be there. So the Court of Appeal would end up with one party. And so the court decided that this was not normal. And, well, it left it a little bit to the national legislator, but the court indicated that the situation had to be changed. And so we changed our competition law on the basis of this Webig case. But it's interesting because on the question that we are discussing now, again, the court says that where questions submitted by national courts concern interpretation of a provision of EU law, the Court of Justice is bound in principle to give a ruling unless it is obvious that the request for a ruling is in reality designed to induce the court to give a ruling by means of a fictitious dispute, so that's the hypothetical case of fictitious dispute, or to deliver advisory opinions on general or hypothetical questions, or that interpretation of EU law requested bears no relation to the actual facts. It's again the same thing. But what is interesting, that is that in this case, the court was discussing procedural matters and not so much substantive matters, where they apply the same important and basic principles. What is the role of the national court? Well, of course, it has to give the Court of Justice all the factual or legal material necessary to give a useful answer. That is what has already been said in the case law mentioned. The information must also enable governments of the member states that will intervene and other interested parties to submit observations. You find again references to Allianz. The national court should define the factual and legislative context, at least explain the factual circumstances being required, and even if the order for reference does not set out that information and that context in sufficient detail, and that's interesting, so as to enable the determination to be carried out, the court says, such a lacuna does not affect the court's fulfillment of the task assigned to it. Again, in Allianz. So it means that the national judge has an obligation and has to help the court explaining the national law, explaining the facts, and so on. But the court does say that even if there are lacuna, it can be quite generous and it can try to look at the case, and it is not as such, it does not enable the Court of Justice to render a preliminary ruling. So the court has a certain margin there, which is quite interesting. On the role of national courts, I think that Judge Duarte has already referred to the recommendations of the Court of Justice to national courts, which you can indeed find, and that's where I found them on the website of the Court of Justice. And it says that the order has to be sent by registered post. You know, in the meantime, that proceedings will be stayed during that phase. The order must be succinct but sufficiently complete with a summary of the subject matter, the tenor of the national laws applicable, and a statement of the reason for the preliminary reference. It should not exceed 10 pages. The courts in Luxembourg are quite strict on that. The General Court, the Court of Justice, you have a certain maximum of pages you can use, as lawyers don't like that, but you have to do it within a certain number of pages. Also, judges here have to be short. And the registrar of the Court of Justice notifies it to the parties in the case before the national court, the member states, and the commission, because member states and the commission can always intervene if they like in preliminary references. Now, the Court of Justice, of course, its job is, if necessary, to reformulate the question. It happens quite frequently that the national court asks a question, for example, on free movement of goods, while it is on services. Then the court will be very gentle and reformulate the question as one pertaining to the freedom to provide services. As said, the court can also decide by an order that the question is already answered, and there is a possibility, which is used exceptionally, for the Court of Justice to refer back the case to the national court, and finally it will normally give the national court an interpretation of union law concepts, and of course not deciding on the case itself. And indeed, it may be that the national court still has a lot of work to do on the basis of an interpretation which is given, so that you cannot even know, even if you're a lawyer in the case, what will be the final outcome. That will very much depend on the national court. So if I still have, I don't know how much time I have, but 2 minutes? Well, okay. I will discuss with 5 minutes. Oh, don't be so generous. So this is not so important. Normally, the procedure is a normal one. There is also an expedited procedure and an urgent preliminary proceedings for area of freedom, security, and justice cases. There it takes only 6 months. Normally it's 18 months. So a competition preliminary reference will normally take 18 months, which may be much quicker than many national procedures, by the way, but it would add to national procedures, so indeed making it longer. But it has a suspensive effect, which of course is interesting sometimes for a defendant to invoke European law, because then you can go on. I could give examples if I had time to do that from my own practice. I will not do it. We might do it in the discussion. Now, what is interesting here is some practical examples from a competition law point of view. Of course, block exemption regulations, I already mentioned them, that also apply in the domestic legal order, and you may find elements of that in two cases, the already mentioned Confederación Española case and the case La Retoucherie. So this is typical court litigation, right, where you have a dispute on the validity of a clause in a contract, and then someone invokes a block exemption regulation and no one knows exactly what it means, and then the court will refer that to the Court of Justice. Of course, also general notices and concepts of competition law. For example, the discussion we had yesterday on restriction by object or effect, which led to, for example, Allianz, Expedia, which we haven't mentioned yesterday, but in other cases. So this is very often preliminary references, because this is a dispute also in either it's a civil litigation or it is an appeal against a decision of a competition authority. Then we have rules of procedure before NCAs, because they are also responsible to apply EU competition law, like in the Vebig case, and general principles, for example, fines for infringement of Article 101, and on the basis of erroneous legal advice. So you cannot say, well, our lawyers have given us the wrong advice, so we were wrong. Excuses, but we didn't know that we violated competition law. This is not an excuse. You can read that in the Schenker case. And of course, claims for damages. And if I have a few minutes, I would like to show you a few cases, because Judge Toade has mentioned the very important recent Kone case on causal link, which adds to the case law of the Court of Justice. You also referred to the Frankovic. So what is between Frankovic and Kone? All the rest, I mean, we have cases on the claims for damages for violations of the competition rules of Articles 101, 102, especially 101. And we have several cases here. It started with Courage and Crean, and then later on Manfredi. And so the court has clarified certain points. This is interesting because we do not really know, and if you read the opinion of Advocate General Cocotte in the Kone case, you will realize that we are in the middle of national law and of union law. Are these principles of claims for damages, like fault, like interest to be paying, the nature of the damage, the causal link, all these elements, are they union law or national law? So it seems now, and the court has not followed the Advocate General who said, well, the causal link is a concept of union law. The court has stick to its former case law, saying that the national law will have to take into account certain principles. And the Court of Justice has turned down a limitation on causality, which existed in Austrian law, but it is not saying that this is union law. But obviously there will be more preliminary references in this regard, because private enforcement is a very important subject these days, and there will be other cases to come before the court. Concluding remarks. As you can see, many important questions of EU competition law have been answered by preliminary judgments, rather than in judgments on appeal, for example, against judgments of the General Court. And of course, because EU competition law is directly effective and decentralized, meaning that you have a lot of cases in the national legal orders concerning EU competition law. It is, I think, the preliminary reference is a very nice model, and it works quite well, I think, for cooperation of the Court of Justice and the national courts. And finally, and this is probably the most typical point for competition law, that is that preliminary references are often used for domestic purposes, and of course this will contribute to the uniform application of EU competition law and the coherence between national competition law and European competition law. I thank you for your attention.
Thank you so much, Professor Stuyck. Actually, I just realized we have been very fortunate today to have heard the views from a judge and also from a lawyer in regard to the same thing. This inside view provided by the judge explained to us the technicalities, whereas the lawyer explained to us, that as lawyers, as practitioners, you shouldn't impress clients during preliminary rulings because there is no room for such. And also, we have learned that we have to deal with the preliminary rulings as in bona fide, as ethical as possible. You have insinuated to some extent that the suspensive effect might be used unethically.